So what we have done so far is we have looked at the general principles of the law of contract and learned what makes a valid contract. I was a little bit not so much in your test. Remember, you wrote a different test from the full-time students. When I was marking the full-time students, I was a little bit concerned. Students don't know the difference between valid, void, and voidable. They're still telling me that if, for example, there were no required formalities, that the contract becomes voidable. No, 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 the contract doesn't become voidable. Contract in that instance will be void. Make sure, go back, make sure you understand the difference between valid, void, and voidable. Then we started looking at particular types of contracts. The first type of contract we looked at was the contract of purchase and sale. Learned that there must be, firstly, this contract must be valid. And then there are certain requirements to put it in the box called purchase and sale. There must be a thing, there must be a price, there must be the agreement to buy and sell. Once you have a contract of purchase and sale, there are certain natural legal consequences that will always apply because it's purchase and sale unless it has been expressly changed. Moving on then, starting tonight for this week, we look at lease agreements. Lease agreements, another specific type of contract that has its own natural legal consequences. In some instances, they are similar to purchase and sale, but in other instances, they will also be different. Let me share my screen. So what I have here in front of me, just quickly, give me a thumbs up if you can see the screen, if I've successfully shared. Thank you, JC. And Matthias. JC is such a lovely name. I had a very good friend when I was at school that was called JC. Okay, what I'm doing tonight, I'm going to do something slightly different. I've actually shared the actual notes from the study guide. Reason being, I don't have a printed copy with me, and I just want to make sure that I don't miss anything. So lease agreements, firstly, and also while I'm here, while I'm thinking about it, once you've worked through a particular unit, always go back to your to the course outcomes, the unit outcomes that are at the beginning of the page, and make sure that you can answer all those questions, that you can do those things. Okay, so what makes a contract of purchase, and what makes a particular contract a lease agreement? Working definition of a lease agreement: contract entered into between two or more parties whereby they agree that one party, called the lessor, let's make this a bit bigger for you, The one party which is referred to as the lessor, and also in some instances, if you're referring to immovable property, you can refer to the landlord. Let's put that in there. So if it's a property that's being leased, the word landlord can be used as a synonym for lessor. Agreement in terms of which the lessor shall give the use and enjoyment of a specific property to another party called the lessee. Or if once again, if it's immovable property, you can use the word tenant in return for the payment of rent. So that is the working definition. From this definition, we can figure out what the requirements will be to make a specific contract a contract of lease and not something else. Let's number them for you. Firstly, the contract must be valid. Similar to a contract of purchase and sale, the contract must be valid. The contract itself is not valid, then it cannot be a valid contract of lease. Once you have this valid contract, there are three essential characteristics that must be agreed upon. Firstly, that the lessor shall give the lessee the use and enjoyment of a specified thing of the property. So you also have, like in purchase and sale, you have a thing. Important requirement here, that the use and enjoyment is temporary. And then they must agree on the rental. This is an important aspect here that distinguishes a contract of lease from a contract of purchase and sale. What is the most important difference between a contract sale and a lease agreement? Potential exam or test question there. Let's see who can answer this quickly. Just before you put your hands up and try to answer, remember, always read your questions carefully. If I'm asking you, what is the most important difference? I've already explained before test one that if I'm asking you to compare, or if I'm asking you what is the difference, you need to point out the differences, not give me two definitions. So if I'm asking you what is the most important difference between a contract of purchase and sale and a lease agreement, I don't want a definition of a contract of purchase and sale and a definition of a lease agreement. That's 0 marks. But also if I'm asking what is the most important difference, there's always only one. I'm not asking you what are the differences. I'm asking what is the most important difference. There's only one. There's always only one most important thing. The others are less important. So if I've asked you what is the most important difference, and you give me 3 or 4 differences, I will mark only the one you wrote first. Remember that. So quickly then, you can remember what a contract of purchase and sale is. What is the most important difference between a contract of purchase and sale and a lease agreement? Come, somebody.
Good evening, Miss Hanako.
Yes, 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 yes.
Can I try perhaps? Okay.
Please.
The difference would be that a contract of lease does not need to comply with any formalities, while a contract of purchase and sale needs to comply with the formalities, if there are any.
No, those are required. Thank you for trying. Thank you for trying. Contracts of purchase and sale don't have to apply to formalities. If you're going to go and buy a bread, you're not going to be signing a document when you buy a bread. So thank you for trying, but no. You are correct. Lease agreements do not have to comply with formalities. There you are correct. But purchase and sale also not. Look at your 3 requirements again and then think about it. Look specifically there at the one that I've highlighted. What is a contract of purchase? What is the definition of a contract of purchase and sale? It is a reciprocal contract for the transfer. Oops, typo. Of possession of the thing. And if the seller to ownership will also pass. So let me lead your thinking here, ma'am. If you buy something, do you buy it with the intention of giving it back?
No.
You don't?
Okay, so
Okay, carry on.
sorry. So that would be that the ownership passes to the buyer, while in the case of the lease agreement, the ownership is temporary. It's like at the end of
Not
the
the ownership.
contract, you have to give it back.
Not the
Or
ownership, the
give
possession. Just be careful there.
the
Not the ownership.
possession.
Ownership is
Okay.
never temporary
Mm-hmm.
unless you subsequently sell the thing to somebody else. The possession, we're talking about the possession, the use
Okay.
and enjoyment of the thing. But you are correct. You are 100% correct. You've got it now. When
Thank
you
you.
buy something, the intention is that you will become the owner. So you want it forever. That's why you buy it. You don't buy something with the intention of having to give it back. Why would you buy something and then have to give it back? That isn't common sense. You don't buy something with the intention of giving it back. You buy something with the intention of having permanent possession, whereas a lease agreement is always temporary. You do not become the owner. It will always come to an end. You will always have to give it back at some stage. Thank you for working with me. There's everybody with me. Yeah, I'm reading your name in front of me, but I'm hesitant to try to pronounce it now. Please pronounce your name for me.
Okay. My first name is Wairirira.
Wairira.
Yes.
Wairira. I love the Oshirero pronunciation. I battle with it so much because you have such strange pronunciation conventions that if you don't know how to say something, uh, if I had to read that the way it's written from my Afrikaans background, you would not recognize yourself. But thank you for working with me. So, lease agreement is temporary. That is the most important difference between purchase and sale and lease. Remember that you're going to get this question. So, let's look then at these three different elements. We already know what the requirements are for a contract to be valid. So I'm not going to go over them again. Let's look at these three different, the other three elements to see what are the requirements in order for it to be a thing, temporary, etc., etc. So, firstly, the thing, the property. It can be anything. It can be anything. It can be something. It can be corporeal. Um, it can be movable, a movable thing that's like a car or a cell phone, whatever. Immovable property, a house, a building. Anything that you can touch, any corporeal thing, something that has a physical substance, can be the object of a lease agreement. Obviously, as is the case with purchase and sale, the parties must be in complete agreement as to what is the subject matter of the lease. The thing can be partially let and hired, or you can grant limited use and enjoyment of the thing. So partially let and hired, use and enjoyment of a part of the thing. So that is when you rent a room in the house, not the whole house. Let's put this in here. A room in a house. So you don't always have to rent the whole house, or the limited use and enjoyment of the thing. For example, space on an advertising board. So let's make space on a wall for advertising. Many schools, for example, around their sports fields, they have fences or walls around their school, their sports fields around the school. They lease space on this wall for companies to place their advertisements on there. It's a way of earning additional income. So they're not renting the whole school, they're not renting the whole wall, they are just renting a particular space to use it for a particular purpose, namely advertising. So it doesn't always have to be the whole thing. It can be just part of a thing, or just for a particular purpose for limited use. But important that it must be identified or identifiable. Both parties must know what is the object of the lease agreement. Something to remember here with regard to that, the subject must be identified or identifiable. If, for example, I pay let's put it here. Payment for a specific parking space. So I pay a monthly amount to NUST to rent an undercover parking space. It's identified, it has a particular number, that is mine. Somebody else parks there, I can get campus security, they'll clamp the car, etc., etc. It is identifiable. That is my parking space. It has a number. That is a lease agreement. If, however, if I pay a specific amount to park anywhere on premises, so NUS doesn't have a system like this, but let's use continue using NUS as an example. If I were to pay a monthly amount to be allowed to park on campus, but not a specified parking space, this will be a valid agreement, but not a lease agreement. The thing that is being leased must be identified or identifiable. Merely the right to park somewhere. The exact space is not identified or identifiable. It can be a perfectly valid contract, but it will not be a lease agreement. If I could just quickly go back here. Your structured application questions. In the exam, you will definitely be getting structured application, can be many various ones. State whether agreement into existence, motivate your answer. Come across structured application, I give you a short scenario. You have to compare the facts in the scenario with the requirements of a valid lease agreement and indicate whether there is a valid lease agreement or not. Remember, a motivation consists of the law, not just copying down the facts. So that is the thing then. It can be anything, any corporeal object. Doesn't have to be the entire thing, as long as it is identified or identifiable. When you study in the notes, always the case studies, the examples that I've included in the notes actually are important. Don't skip them. They serve an important purpose. The full-time test, I gave a question about purchase and sale, about latent defects to the full-time students. It wasn't in your test, which was absolutely entirely based on an example in the notes. And not a single student, not one of the students actually got that whole question right, because nobody had bothered to read the example. It was a bit of a trick question. which they would have been able to answer if they had read the example. So don't ignore my examples. They serve a purpose. You might be interested to know this. In fact, lease agreements are normally quite interesting for students at answer because most of you end up leasing premises. If you rent a farm and there is a house on it, that house will form part of the lease agreement unless it is specified that you rent only the farm but may not live in the house. If the lease agreement is silent about that, any immovable structures on land will form part of the subject matter. Movable property, however, furniture, is not automatically included unless it is specified in the lease agreement that you are leasing a furnished house, a furnished room. But otherwise, it's just the building. Okay, then temporary use and enjoyment. We've spoken about this. This is what distinguishes a contract of lease from a contract of sale. It is only granted temporarily. Parties must agree on the duration when it will come to an end. However, that date does not have to be specified. It can be indefinite, provided that there is a provision in the agreement for it to be terminated. So you can lease a property indefinitely, provided there is a provision that either party can, by following certain steps, terminate the lease agreement. There's no valid lease that says you rent the room forever. It doesn't have to say until the end of the year, as long as there is a provision made for the manner in which to terminate the lease. It can also continue until the occurrence of an event that is bound to happen, although the time for the occurrence is unknown. Let's give you an example here. Let's choose Asser. That's an easier name to pronounce. Asser, oops, mustn't be caps, can rent a room in my house until I die. Do you think that's a valid lease agreement? Asser, do you think it's a valid lease agreement? You could rent a room in my house until I die. Who thinks it's a valid lease agreement? Give me a thumbs up. Asser thinks it's a lease agreement. Yes, Asser is 100% correct. We don't know when I'm going to die, and hopefully it's not going to be anytime soon. But there will come a day when I will die. So it can be an uncertain future event in the sense that we don't know when it is going to happen. But it is certain that it will, in fact, happen. I am going to die. So it is temporary. Asser, in my house forever. That's not a lease agreement. And that one will be a lease. So it has to be temporary, but it doesn't have to be a fixed date. Then the rental, if parties have not agreed on the rental amount, then there will be no lease agreement. They can also agree that a neutral third party can agree on the lease, similar to purchase and sale. Important here, similar to purchase and sale, it must be in money. If it's not in money, if we agree that Asser will rent a room in my house, that instead of paying me, he will help me fix things around the house, that will be a valid agreement, but not a lease agreement. There is one exception, however, namely the so-called rural lease, farmland, where the rental can, in total or in part, be a specific part of a definite quantity or weight of whatever is produced on the lease property. So an agreement that will my farm and pay me half of the monthly income. So this is only applicable to rural leases, to farmland, not to a property, an urban property, but for farmland, it will be a lease agreement. Any other lease agreement, payment has to be in money. Okay, any questions so far? No questions. Okay, so then that is now what makes a lease agreement. So we have a lease agreement. Once you have a lease agreement similar to purchase and sale, there are certain duties of the parties that will always apply, provided or unless they have been expressly excluded. So natural legal consequences. Let's look then firstly at the rights and duties of the lessor. Duties of the lessor include delivery of the thing, the duty to maintain the thing, the duty to grant the lessee undisturbed use and enjoyment, and if it is property, the payment of rates and taxes. Don't you just emphasize there that the use and enjoyment must be, it is temporary, but while it lasts, it must be undisturbed. So firstly, the duty to deliver the thing. When we did purchase and sale, we looked at what delivery means. Delivery has a similar meaning when we are talking about lease. It doesn't mean taking the thing to the purchaser or taking the thing to the lessor, or to the tenant, to the lessee. It means making it available. The lessor must place the thing at the disposal of the lessee so that the latter can take free and undisturbed possession of it. Similar meaning there to what we have in purchase and sale. What must be delivered? Whatever has been agreed upon, as well as all articles and accessories without which the thing cannot be properly used. So if you rent a house from me, obviously I need to give you all the necessary keys as well. At the time of delivery, it must be in a proper state of repair and in a condition fit for the purpose for which it is let. So if I'm renting a room for you to stay in, it must be habitable. Somebody must actually be able to live there. It can't be falling uh, apart. You must be able to use it for the purpose for which it has been let. In all of these instances, I'm not going to repeat it every time, these are contractual duties. Duties that the lessor has in terms of the contract. So if the lessor does not fulfill his duty, what will this legal term be? The lessor doesn't answer quickly. Somebody shouted out, Ryan, the lessor has a duty. He doesn't do it. What do we call that?
Invalid contract.
No, it doesn't suddenly become invalid. Oh dear, people, you've had too long recess. You seem to have forgotten what you've done beforehand. There's a valid lease.
Isn't it?
Narisha?
Isn't it? Isn't it Morat creditors, something like that? With
don't specify. Don't specify Mora, and why would it be Mora creditors? It's the debtor. The person that needs that is the lessor here. Remember, we're talking law. There's all kinds of things popping up now. Debtors and creditors in law is not always the person that has to pay. I've explained this. It has a wider meaning. When it comes to delivery of the thing, making the thing available, the person that has to do this is the debtor. There are various obligations involved in a particular contract. Now we are talking, just for the sake of illustration, we're looking at the duty to make the thing available, the duty to deliver the thing. The person that has to do that is the landlord. So the landlord will be the debtor with regard to that particular obligation. So it won't be Mora creditors. The debtor has a particular duty. He doesn't do what he's supposed to do. What do we call this in contractual terms? You weren't too far off, Narisha, except I wouldn't, Mora creditoris is not correct. But Mora creditoris is a type of what? Come on, people. Yes, ma'am.
Yes, ma'am. Perhaps breach of contract.
Yes, yes. You're making it too complicated. Breach of contract, as simple as that. It is simply, I didn't ask you to specify what type of breach it is. Because that would depend on the facts. If delivery is done late, then it will be Mora debitoris. If it isn't the proper thing, it will be defective performance. I didn't ask you to specify what type of breach. Just needed here to say, to understand that it is breach of contract. People, we are dealing with a valid contract. A contract that is valid doesn't suddenly go void. Once it's valid, it remains valid. The fact that somebody does something wrong, doesn't do what they're supposed to do, messes up, doesn't void the contract. Please understand that. It remains valid. If it doesn't remain valid, remember, a void contract is a nothing. There are no rights and duties that flow from a void contract. So if the contract suddenly becomes void because the thing hasn't been delivered, the tenant, the lessee, will have no legal recourse, won't be able to do anything. It is valid. It's breach of contract, and you will have, depending on the circumstances, the ordinary remedies for breach of contract. I trust you know what those are. If not, go back to contracts and revise them. So we've had the duty to deliver, the duty to maintain the thing in a proper condition. I quite often get questions about this. Students that come to me and say, but I'm renting a room and the ceiling is collapsing. Must the landlord fix it? The general answer to that is yes. But what I always tell people when they come and ask me questions like that is, I will need to see your written contract. Remember, these duties are natural legal consequences that can be changed. So a lease agreement can state that the tenant is responsible for maintenance. That is not uncommon. It is not unknown. But if the lease agreement isn't specific about that, the duty to maintain the thing in a proper condition is the duty of the landlord. The duty to ensure undisturbed use and enjoyment. The lessee must not be disturbed. The lessor undertakes that you will not do anything which unlawfully interferes with the lessee's use and enjoyment. Similar related here to the guarantee against eviction. The landlord guarantees that no person with a superior title will disturb or evict the lessee's use and enjoyment. It does not, however, extend to interference by a third party who has no right to the property. So unfortunately, if you're renting the property and some squatters move in, you will have to deal with it. You cannot, obviously you can request that the landlord assists you, but the duty to ensure undisturbed use and enjoyment does not go as far as extending to interference by unlawful third parties. Unlawful disturbance does not include entering the property for the purpose of inspection or maintenance. So the landlord may enter the property for inspection purposes, maintenance purposes. Obviously, they will need to give you proper notice if they need to come onto the property for maintenance purposes. They can even insist that you vacate the property if the maintenance is of such a nature that you cannot, while the maintenance, the repairs are ongoing, live there. They can request that you move out for a while. But once again, only temporarily and only for as long as is absolutely necessary. Exercise powers must be exercised reasonably. And then the duty to pay taxes. This can also be changed, but in general, property taxes, your municipal account is the responsibility of the landlord. Then the duties of the lessee. Firstly, the duty to pay rent in the agreed manner at the agreed place, as specified in the lease agreement. The general rule, I believe most of you don't know this, the general rule is that rent is payable in arrears. So you only need to pay at the end of April for April's lease. Don't now go running to your landlords and tell them, my lecturer says I only need to pay you at the end of the month. These are natural legal consequences. They can be changed, and most standard lease agreements state that the rent is actually payable in advance. So in the beginning of the period. The duty of proper use and care of the property. Although the lessor, the landlord, has the duty to maintain the property, that does not mean that the tenant can do what they want to and break it down. Thing must be used in a proper manner and for the purpose for which it was let. This is important. For the purpose for which it is let. So if you rent a property for residential purposes, you cannot start using it for business. You've rented a room to live in. You cannot open a hair salon in that room. Property must be used with reasonable care. If there are breakages, damages, not that exceed normal wear and tear, but that are caused by the lessee, the tenant, they will be responsible to fix it. So if you break a window because you threw a ball, kicked a ball, you have to replace the window. But if the ceiling starts leaking, the landlord needs to fix it. Duty to return the property. Obviously, the lease is temporary. That's the whole essence of a lease, because you're renting it temporarily. Once the lease comes to an end, you have to give it back. You have to return it in the same condition. Fair wear and tear expected. Any questions? Any questions? Okay, I have a very bad thunderstorm that is starting to make a lot of noise outside my house. So I'm going to stop here for now. We can finish the rest of the unit on Thursday. Last questions before I say goodbye? Okay, thank you so much for joining. I'll meet you on Thursday then. Bye.